The chair lays out House Bill 3181, Representative Dutton's bill, and recognizes its sponsor, Senator Paxton, to explain the measure.
Thank you, Mr. Chairman. Thank you, members. House Bill 3181 addresses a critical issue in family law, the enforcement of court-ordered possession and access to children. By law, a child's best interest is to be prioritized when determining access to and possession of a child. Therefore, ensuring compliance with these orders helps protect the best interest and well-being of children involved in custody disputes. However, the Family Code lacks some needed tools to curtail a repeated pattern of one parent denying the other parent their court-ordered time with the child. House Bill 3181 addresses this by providing stronger consequences if the parent has been held in contempt of court for the denial of court-ordered possession or access to the child at least 3 times previously, including authorizing the court to modify the court order or decree providing for the conservatorship or for time with the child, mandating that the additional access ordered to make up for the denied time totals to twice the duration of the time that was denied, and providing financial consequences by limiting the court's ability to waive attorney's fees and costs for repeat offenders. House Bill 3181 is an important step to ensuring that court-ordered possession and access to children is respected. Members, this bill unanimously passed out of the House Committee on Judiciary and Civil Jurisprudence and passed the full House 135-6. Thank you, Mr. Chairman and members, for your consideration.
Thank you, Senator Paxton. Members, any questions for the sponsor on House Bill 3181? Very well, we'll open public testimony on House Bill 3181. Chair calls Honorable Carl Hayes, George Saldana. And if anyone else wishes to testify on, for, or against House Bill 3181, please come down and let us know so we can get you in the system and hear from you. Judge, welcome. Introduce yourself and go ahead.
Hi, Chairman Hughes, members of the committee. My name is Carl Hayes, and I have the honor of serving as a family court judge of Hays County, Texas. I'm also a member of the Texas Family Law Foundation, but I want to make clear that I am not testifying today in my capacity as judge of the family court in Hays County, nor am I testifying on behalf of the foundation. I did help draft this legislation, which I think is very important. 105.006 of the Texas Family Code provides that in every single order that is rendered by a court involving children and possession and access, the following language is to be included: that failure to obey a court order for child support or possession of or access to a child may result in further litigation to enforce the order, including contempt of court. A finding of contempt may be punished by a confinement in jail for up to 6 months, a fine of $500 for each violation, and a money judgment for payment of attorney's fees and court costs. Unfortunately, those words are meaningless for a large number of individuals who come into court trying to seek enforcement of their possession and access orders. I have lost count of the number of attorneys, and as recently as yesterday, when I was explaining to an attorney that I was going to come testify on this bill, the attorneys tell me, "Judge, you're the only person that has ever held someone in contempt of court for violating a possession order. You're the only judge that we've ever gotten attorney's fees awarded for when they violate a possession order." Because the problem is we've given too much discretion to judges, and so when I was practicing law, and I've been practicing for 40 years, I've been the judge of the family court for 6, but I would routinely have to tell people when they came into my office saying they were trying to enforce an order, well, you know, we can go into court, you're going to spend a lot of money, but you may not get the result that you want because the judge is likely to give them a slap on the wrist. This gives the opportunity for this body to set a public policy to say, we value both parents' rights to have possession and access of their children. We do enhanced penalties on all sorts of offenses. We tell people when they violate DWI laws, we do enhanced penalties for that. We tell people when they can't have probation for certain offenses. This is doing the same thing, and it is endorsing the public policy of the state of Texas that children need two parents in their lives. I'll yield for questions.
Thank you, Your Honor. Mr. Saldana.
Thank you. My name is George Saldana. This session, I've heard passionate debates over gun rights, medical freedom, educational access, and rightfully so. But we must not overlook the most sacred and constitutionally protected rights we have, parental rights. Under this bill, a parent must prove 3 separate violations through contempt proceedings before the court will ever consider relief. That means hire an attorney not once, but 3 times, each costing thousands of dollars. That's simply out of reach for most working class and poor parents. We already have tools to address these violations. The mechanism is interference with child custody under Texas Penal Code 2503. Yet law enforcement and prosecutors routinely refuse to act, telling parents, take it back to court. It creates a financial incentive for lawyers, and it takes away from our parental rights. Let me ask you, would we ever require a citizen to file 3 lawsuits to exercise their Second Amendment or gain access to medical care? Then why are we forcing parents to file 3 costly contempt actions just to see their children? There's a better way. Instead of this heavy, unaffordable burden, the state can allow the police reports to replace the contempt actions to be able to, that's my solution to this bill. I love it. We're in the right direction with parental rights. But ultimately, sir, I do believe that we have viable mechanisms to enforce these court orders. We just need the judicial branch to enforce them for us. Thank you.
And thank you, Mr. Saldana. Senator Paxton, you have the panel.
Thank you. I appreciate it. And Mr. Saldana?
Yes, ma'am.
So you might be happy to know that I actually just, I'm carrying, and we have passed out of this chamber, Senate Bill 2794, which does address exactly, it creates the police report record on the criminal side. But this is on the civil side. And Judge, do you have any responses to some of the things he brought up?
I agree with him 100%. The problem is...
Can you lean into the mic?
Oh, I'm sorry. I agree with Mr. Saldana 100% because he's saying the problem is we don't have a judge who enforces. And so this forces the judge to enforce the law. It's a 3 strikes and you're out rule. And that's been the problem. Sometimes we get 3, 4, 5 strikes and people consistently, and you heard you were the sponsor of Senate 718 last. You heard the stories of the people who for years have been trying to get judges to do something, and nothing happens. And so I think a remedy, and that's why it's great that you're sponsoring you're carrying both of these, because we need something on the criminal side. We also need something on the civil side. Both of those working together is what's going to help the children of the state.
Thank you. I appreciate that. And I appreciate the issue that you bring up, Mr. Saldana. And I think that's the hope with both of these bills, that it comes at it from both sides. The other one, the 3 strikes policy that is 2794, is not law yet, and so you may not be familiar with that, but I think it will go a long way to help on both sides. And thank you both for being here to testify on the bill. We appreciate it very much.
Senator, if I may,
Sure.
just real quick. I've been in the Harris County Family Courts for the last 8 years, and this is my niche, interference with child custody. I haven't seen my boy in 4 years, and it's routinely just disregarded by some of these judges. And of course, I'm on the judicial accountability for qualifications of judges because, I can't miss any more time with my child. And so I thank you guys for all your help.
Thank you. I appreciate, and I'm so sorry about your situation, but appreciate that you're here to testify so that people can know this really does happen. And hopefully this legislation, both of these approaches will go a long way to helping people who are not getting their proper court-ordered time with their child due to interference sometimes with the other parent. Thank you.
Thank you, Senator.
Thank you.
Senator Birdwell, you're recognized.
Thank you, Mr. Chairman. Judge, you said you weren't here to testify in your capacity as a judge. I hope you don't mind if I ask you questions in your capacity as a judge.
I can answer questions, but I'm not here officially as a representative
I
of this
understand,
county.
but I'm going to ask you about your experience. Well, first, let me say that not too many people come in and say they want less discretion. And given the nature of what you're describing, what we're looking for is faithfulness. And what I think you're complaining about is, sir, is the lack of faithfulness to a court order.
Yes.
So let me ask this. How many times have you seen the same couple, even though, presuming there's a divorce, but the same couple in your court on this issue related to not being faithful to the court order? How many times have you seen that couple?
Well, I'm going to be the anomaly because, as I told you, I have no qualms about sentencing someone. And so now in private practice, because I've been a lawyer for 40 years, in private practice, I saw it dozens of times that we would come into court 2-3 times and not get any sort of punishment on the offender. So that's why when I took the bench 6 years ago, I was like, I'm going to make sure that doesn't happen in my court. And you'd be surprised how if you sentence someone, and you don't have to sentence them to a long amount of time, you sentence someone to a weekend in jail, that usually cures the problem. And so I have found that to work. We have someone come in and I will sentence them if they are found in contempt. And that's the thing too, they have to meet the requirements because there are strenuous requirements for someone to be held in contempt. You have to meet certain elements. Go ahead, sir.
I hope you don't mind the back and forth.
Absolutely not, sir.
Is contempt findable in that moment, or is contempt yet another docket entry?
No, contempt is findable in that moment because they come into court on a motion for enforcement, and at that hearing, it must be shown that there is an order capable of being enforced, that there is a violation of the order, and that there's intent to violate the order. If I find all three of those things, I find the person in contempt.
They don't go to trial at another opportunity?
No,
so, okay.
no. And Mr. Saldana's right. It helps to have an attorney be able to do that because it's a technical type thing. If you make a mistake in how you plead your motion for contempt, the person can skate on the violation because it's a criminal. It's quasi-criminal, which means we want to make sure that all the I's are dotted and the T's are crossed if we're going to put somebody in jail. So it's much harder for an individual who's representing himself or herself to be able to get a contempt finding. But if we did something like this, it would take by the third time, I think you would have somebody who clearly would get the message.
So maybe my question was appropriate, but because of your experience being prepared to sentence somebody, you've never seen somebody for the third time. Because what I'm trying to
I have never seen anybody for the third time because after I have sentenced them, I never see them come back.
Let me ask your opinion then. Is 3 too high a threshold? Should it be lower? So that if, okay, one time, come back a second? Because it would seem to me that 3 may be too high. I mean, I support the bill if it moves this way, but...
And I understand your position, Senator Birdwell. The bill, when it was originally introduced in the House, had that it was on the second violation. And as a result of the work in committee, they came up with this, doing 3 strikes instead. But it was originally introduced, and I originally helped draft it as the second time you come back, the judge can't put you on probation. They have to sentence you to jail.
Okay. Now, in the bill itself on page 2, it says the court may not place the respondent on community service or suspend commitment if the court finds the respondent is in contempt. So that when you talked about sentencing somebody, the way I read this is that if they are found in contempt, the order the original order on the fourth occasion, the original.
Actually, the third occasion.
Third occasion, okay.
Third
So on the
occasion.
third occasion, so that you don't have to complete 3, but at the completion of the third.
Right, it would be the third strike. You come into
Because
court.
you're
and
not
it's-
having to
and
docket it another
two
time.
times. Two
Okay.
times it's happened before.
Okay.
This is the third time, and you're going to jail.
Okay. But you talked about going to jail. The way I read this, it sounds like confinement is not an option. The way I read this, is that a correct reading?
No, confinement is an option because
It is an
it's what happens routinely is the judge will find someone in contempt, sentence them, and then probate the sentence, and they give them probation every time. So that they keep doing that every time, and so there's never a penalty because they're put on probation. And this is saying, look, after the third, you don't
So this
get
is
probation.
saying you don't get probation, you don't get the
Correct.
public, okay, so that therefore it requires a confinement order of
It
some type.
requires confinement, and as I said, it could be something as short as a day confinement, but it
To
requires
get your attention, so,
exactly, because
Okay.
you can sentence someone for up to 6 months in jail. I've done that a couple times, but not in this situation. But really, putting someone in jail for a weekend is usually enough because they get a taste of what it's like, and they go, okay, this judge is serious. I know I need to abide by the court order.
in your court, when the parent seeking the opportunity for visitation, that is not the primary custodial
Right.
parent, the presumption is that the parent that is not in the primary custodial condition is paying child support. Do you review that plaintiff's payment of child support as part of your review of their request for access and visitation to the child?
No, because there's actually a statute in the family code that possession and access is not tied in any way. You can be completely years behind in your
You can be in arrears for,
and still that doesn't keep you from seeing your child. The legislature has
Right.
said that.
I don't want that to be, I'm just, what I wrote down in listening to your testimony, I'm wondering, should the bill contemplate such an action? That not that I want the custodial parent to leverage lack of payment against the non-custodial parent, but I also don't want to reward the non-custodial parent for failure to being in arrears.
Well, and the legislature said the two are separate, and so if someone comes into court, they can owe support. But I don't look at that. I look at just whether if the only issue in front of me is whether or not there's possession and access that's been denied. Now, I will tell you, in quite often, a motion for enforcement is filed against the custodial parent for violations of possession and access. The custodial parent, if they're owed money, is going to file their own counter motion, and those two motions will be heard at the same time because the custodial parent's going to say, wait a minute, as long as we're going into court, I'm owed money, and judge, I want you to consider that. But I can't hold it against the person owing money in terms of not giving them the opportunity to see their child. The two are separate because we don't keep, if people for whatever reason are unable to pay their child support, that doesn't mean that they shouldn't see their kids.
Correct, okay. So you've heard the discussion here. How many times have you been in court seeking the opportunity to see your
I've
children?
been in Harris County Family Court for enforcement actions for the last 8 years.
But how many times, I mean, how many
Hearings?
docketable, I assume it's a docketable item. How many docketable items? Is it too many to remember?
Yes, sir. Yes, sir. I know it's well over 40 times I've been having to drive from San Antonio to Harris County. And that's where that's where my issue is that when I have to drive from San Antonio to Harris County to pick up my child by the conditions of the court order, I call law enforcement because, as Judge said, you need to have valid order, you need to have a violation of your order, and a willingness to violate. And so 2 of those elements I can meet, but if there's not a law enforcement officer that's going to give me that violation, which I can use in court to prove that, then I can't go to contempt. So in my contempt action that I filed, there was 7 violations. We put a total of 12, and I think the judge just got tired of hearing about them, so she ruled on 7. She placed my ex on community supervision for 10 years. And I'm thinking this is a win. Mom doesn't go to jail. We're going to start following the court orders. Right after that order for probation was given and signed, she violated again. And it's gotten so bad that now these Harris County judges, they're not enforcing the law. Law enforcement's not enforcing the law, but I have mechanisms to enforce this court order, and nobody's doing it, and that's where my frustration.
And this may be a question for the judge, and I thank the chairman for his deference here with digging into this. Are the costs of the non-custodial parent, given them multiple attempts, are those collectible as a summation, or is the cost of, if you make the ruling on a docketable item, is the cost of him coming to court for that one time is all that can be collected in attorney's fees, costs, et cetera. But listening to the story, it sounds like years of expenses that will never get recompensed. Tell me where.
Well, and Chapter 157 provides that in most instances, the court is supposed to award costs against the party who violates the court order. But it allows for the court to exercise discretion. And so what happens in the majority of cases is the court doesn't award the attorney's fees. The bill
does.
says third strike, the court has to award attorney's fees. And the thing about it is the attorney's fees and costs are awarded as child support, which means they can be enforced by contempt.
Right.
So it's not just a money judgment saying that the custodial parent owes money, say to Mr. Saldana. He would be able to collect it because it's a child support obligation that doesn't go away, and it's enforceable by filing a motion for contempt. It also can be enforceable through income withholding.
Okay. Let me ask one more question,
Sure.
Mr. Chairman, and I'll ask it of the judge. I get the sense that part of the reason for this desire not to do something is that because particularly in the large urban areas, judges that get overruled by an appellate judge expect that because they're a judge placed in a position of higher authority. Is there an institutional inertia that a family court judge just doesn't really want to deal with this issue because they don't want to rewrite a peer judge's original order because they're at the same level of district family court? Is there a concern there that judges are just not wanting to deal with this because, well, you know, Jim's sitting on the bench, here's the case today, but Susan wrote the order 6 years ago. I don't really want to, you know, change because Susan's a peer.
It's not that. It's that built into the law, and this is in the area of family law, the standard by which cases are reviewed is abuse of discretion. And that is a very loose standard. And it's just that judges have in this area too much discretion, which is why on the criminal side, the legislature has seen fit to put some restrictions on judges. And they've said, look, there are certain instances you're not going to be able to grant probation, even if you want to. Even if you wanted to, you can't do it. There are certain instances where someone comes back 2 or 3 times on a DWI, you're going to give an enhanced penalty. And they didn't leave it up to the judiciary to decide, because I think that's the problem, because judges want to, go along to get along, and they want to try and promote.
So you've just answered the question. The institutional inertia is yes.
It is, because they want people to get along, and it's like, okay, I'm not going to hold you in contempt. You guys are going to work this out. Everybody's going to, it's this Pollyanna attitude. And unfortunately, the people that suffer are people in Mr. Saldana's position because they're having to keep coming back, and the courts are like, well, I'm doing my best here.
Yeah, we don't live in a Pollyanna world, so.
Yes.
Thank you, Judge, for your service. Thank you for the information. God bless you, sir. Thank you for the bill, Senator Paxton. Thank you, Mr. Chairman.
Thank you, Senator Bardwell. Judge, I have a practical question. Of course, your testimony yourself and Mr. Saldana, your testimony is very helpful. So I have a practical question about what you've seen in your court. So I know with the custody situation, sometimes the two parents will meet. We'll meet at the Whataburger at X location. We meet there for the handoff, or one parent will go to the other parent's home or something like that.
Right.
So how many situations do you see where the parent is clearly the one who is not cooperating? Either they don't show up with the child, or the non-custodial parent arrives at the home and the child is not given to them. How many times do you see that versus when the child says, Dad, I don't want to go with you, and maybe the other parent is coaching them, maybe there's pressure on them? How often do you see that situation, if at all?
You see that. I mean, you see it in both instances. Far too often, it's the one parent just not showing up. And in those situations, we often get that it's a combination. Well, I didn't show up for the drop-off because your son or daughter said they don't want to see you. And it's like, well, how do we know that? But it's a combination, and it's completely under the control of the custodial parent, because they've got to transport the child. They've got to be able to bring the child to the location. The child can't transport themselves. And so it really sits with that custodial parent to decide, am I going to meet at the Whataburger? Am I going to do this or not? And that's where we run into a problem, because as Mr. Saldana was saying, most people, when they've been involved, they know they need to do something to prove the situation, what happened, because you show up at the Whataburger, person doesn't show up, how do you prove that you were there? Well, as an attorney, we would say, you go buy something at Whataburger, so you've got your receipt, or you have a police report, right? But so far too often, people get discouraged, they get back in the car, they go home, and then they can't prove that they didn't get their possession and access on that particular day.
I see. And this is all so helpful to us. Let me ask you about that more difficult situation where, let's say the parent, the meeting takes place at Whataburger, but then the child says, Dad, I don't want to go with you. That's more of a factual inquiry, I would think, by the court to determine whether the custodial parent is unduly influencing, that sort of thing. Subject to the rules of evidence and the court's judgment, could this bill be applied in a situation like that as well, if the court was convinced that the custodial parent was influencing that child, coaching that child?
Alienating the child. Yes, it would be helpful in those situations. Yes.
Very good. Thank you, Senator Bardwell.
Thank you, Mr. Chairman. And again, I beg the committee's deference. One question, but in the gentleman's circumstance, Houston, San Antonio are both under the jurisdiction of the state of Texas. What about the issue of the parent, be they custodial or non-custodial, is in Texas, and a different parent is in a different state, particularly if it's the custodial parent in another state? How enforceable is this? What's the mechanism by which the parent that is aggrieved, that seeks this bill, to the parent that is not aggrieved, that's in a different state? How applicable is this? What's the mechanism by which, if it was San Antonio to Baton Rouge, how does this solve it?
The mechanism is Chapter 152 of the Texas Family Code. It's a uniform act that Texas and all 50 states have passed. It's the UCCJEA, the Uniform Child Custody Jurisdiction and Enforcement Act. And it provides that you can enforce a child custody order in any state, and there's a process by which you do that. And so you would have to implement that act if you wanted to enforce the order in, say, California or New York or wherever. You would have to trigger the provisions of that act. It becomes more complicated.
was gonna ask,
but we
is
do
that-
have a mechanism for enforcing court orders across state lines.
But at that point, the state of Texas, be it the Attorney General or state law enforcement, solicits at the parallel level, the other state to act?
There are provisions for that. And there are provisions also, depending upon where the order is rendered. If an order is rendered in Texas, it's enforceable in Texas even if the other person moves. And so a Texas court can issue can file a suit and serve the person in California and say, you need to come here and respond to this violation of the Texas order. Now, if it's like a California order, and the person is in Texas, they take the California order, they domesticate it, they file it here, they register it here, and then Texas can enforce that California order as if it was a Texas order. That's what Chapter 152 provides for.
And then the other states can do the same as if it were a Texas order in Louisiana?
Exactly. And there are provisions in 152 that even authorize, if someone has fled with the child, that authorize law enforcement, the issuance of a warrant to take possession of a child and law enforcement to go seize a child if they've been improperly removed from the state. So it helps in parental kidnapping situations as well.
Okay.
But if the DA doesn't pick up these charges, you lose your kid. And that's the problem, is that the DA is it's just like the House Bill 17 that they wanted to rein in rogue district attorneys for not enforcing marijuana laws and abortions. It's the same thing with interference with child custody. It's a lot easier to utilize the criminal system to enforce that court order, because if you have a right to your child, this is immediate. I shouldn't have to pay $10,000, $5,000, $15,000 to enforce a perfectly good order with mechanisms. And so...
Yeah. Thank you. Thank you, Judge. Thank you, Mr. Chairman.
Thank you, Sir Bordwell. Members, any other questions for Mr. Saldana or for Judge Hayes? Thank you both for being here. Thanks for your testimony.
Thank you.
Is there anyone else present wishing to testify on, for, or against House Bill 3181? Seeing and hearing none, public testimony is closed. Bills left pending at this time.